Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Yes, Your Honor. I'm here for Tony Hernandez, He's in Del Rio in felony court this morning, and I just want to let the court know that that's where he's at.
All right, is he in Del Rio in felony court for jury trial?
No, not for jury trial, but he's there on the defense.
All right, tell him his client is here on trial.
He does know that, so he just wanted to let the court know that it's possible he might not make it back till late this afternoon.
Okay, tell him he needs to make it back because this is a jury case.
Okay.
All right, and tell him his client is dressed for trial in a Nightmare from Elm Street t-shirt. The zombie apocalypse may be upon us.
Yes.
All right, there we go. That was a long one. Welcome back. Welcome back. We haven't used that soundbite in a while, and now I know why. It has a huge intro. It's too quiet. So, good one from Judge Boyd. Tell your client, tell the lawyer your client's here to court and he's wearing a Nightmare from Elm Street t-shirt. Oh, yeah, good stuff. Welcome to the Court of Public Opinion. I am the Recovery Addict. We have a document read through tonight in the Young Thug trial. Have to say welcome to Ashley. Ashley was first in chat tonight, which means she's probably going to have to maintain the internet all night long. So you've got the overnight shift, Ashley. Hopefully you're up for that. We hope you are, because the way things have been going, things be happening all evening. So congratulations, Ashley. You've won before, and now you've won again. Long time no see. It's been a bit, Ann. How have you been? How's the kids? How's everybody? So, anyway, we are back. We want to cut straight to the chase here. For those that are not familiar, the Young Thug trial, this has been going on in Georgia. I think we're on about day 90 today. Okay, so several months of trial.
Squirrel!
Ooh, that was loud. Anyway, day 90 in court. It's had its moments of spice. Most recently, there was an instance where a witness was a state's witness. He had an immunity deal with the state, and that's when you testify, and in return they don't charge you for the things you're testifying with. And so he's calling out and he's testifying against some of his former people in the gang, and so he gets up there on the stand, and the prosecutor asks him a question, the one he's made the deal with, and the question was, "How old are you?"
This is not Burger King.
And
people do not get to have it their way.
And he's like, I'm grown. I'm an adult. He's like, when were you born? What's your birthday? And he's like, I plead the fifth. It melted down at that point, okay? So it absolutely melted down. He gets arrested, gets hauled off because now he's in violation. And it turns out that over the weekends, they talk things over. The next Monday morning, they get back in court. The judge, instead of starting court at 8:30 in the morning, calls him, his lawyer, who, let's see, the prosecutor, a bailiff or two, a court recorder, and the judge. They all get in the judge's chamber, and they do an ex parte hearing of this witness who was sworn in at the time, okay? You know when the judge says, hey, when you leave the stand, you're still under oath, you can't talk to anybody? Apparently that doesn't mean the judge. In the judge's book. So that happens. The guy agrees to get back on the stand. But the other lawyers somehow found out about this ex parte hearing. And Mr. Seal particularly raises the motion and says, hey, I want to know what happened in that hearing because we should have been there because he was under oath and you were talking to him and that shouldn't be allowed. And the judge is like, well, you shouldn't know about the hearing. So you have to tell me who told you. And it doesn't matter because you shouldn't know about it. Ends up that lawyer gets held in contempt, gets ordered to serve 20 days in jail, okay? And that's where we're picking up, okay? Because that lawyer now is a little bit angry, he's a little bit mad, and so he files a few documents, including, well, let's see this one right here, which, if I can pull up here full screen for you guys, this is dated today, Wednesday, June 12th at 3:02 p.m. So this is fresh off the press. State of Georgia versus DeMonte Kendrick, defendant. Motion to recuse Chief Judge Ural Glanville. The defendant, Mr. DeMonte Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to recuse Chief Judge Ural Glanville from the continuing to preside over the present case and requests that the present trial be temporarily halted until the present motion is heard by another judge of the Superior Court, consistent with the uniform rules of the Superior Courts of the state of Georgia, stating the following. It is vital to the functioning of the courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that the court should be fair and impartial. The present case involves a 65-count RICO indictment against 28 individuals. Jury selection in the case began in January of 2023, with a jury trial beginning in November of 2023. Given that the state has presented less than half of its current witness list, which the state has announced could be increased based on circumstances, the trial should last well into 2025. The 6 defendants presently on trial, including Mr. Kendrick, have been denied bond and incarcerated for over 2 years. A central figure, perhaps the central figure in the state's case, is Kenneth Copeland. On Friday, June 7th, 2024, Kenneth Copeland was sworn in. Despite being warned by Chief Judge Ural Glanville that incarceration may be the result of refusing to testify after being given a grant of immunity, Copeland refused to testify on that day. Copeland was ordered incarcerated by Chief Judge Glanville on that date, and Chief Judge Glanville instructed Copeland and all parties that Copeland would be returned to court on Monday, June 10th, at 8:30 a.m., where Copeland would announce whether he was prepared to testify. On Monday, June 10th, all defense counsel were present in the Fulton County Courthouse at or around 8:30 a.m., admitted entrance into courtroom 1C, and seated within by 9 a.m. Defense counsel waited. And waited. Between 11 and 11:30 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. Attorney Brian Steele, counsel for defendant of Mr. Williams, he's the one that got held in contempt, inquired with the court as to the delay and what had occurred prior to Chief Judge Glanville taking the bench. His inquiry was not accepted. Unknown to any of the defense counsel during the waiting period in the morning, upon information and belief, an ex parte meeting was held in Judge Ural Glanville's chambers on June 10th. Among Chief Judge Ural Glanville, the ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witnesses Kenneth Copeland, and Copeland's attorney. Ex parte hearing. No member of the defense counsel was present at the ex parte hearing, despite the subject matter of the meeting being a critical phase of the trial. Upon information and belief, neither Chief Judge Glanville nor any member of the court staff, nor the Fulton County DA office, made any member of the defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during the ex parte meeting, or after the ex parte meeting. Copeland briefly testified prior to a lunch recess. One or more members of defense counsel were later made aware of the ex parte meeting with sworn witness Copeland and made aware of at least some of the content and subject matter of the ex parte meeting. Upon information, I want to say inflammation for some reason. Upon information and belief, the following events occurred at the ex parte meeting with sworn witness Copeland in the chambers of Chief Judge Ural Glanville. This is what they think happened. Upon information and belief, Copeland announced that he would invoke his Fifth Amendment rights and not testify. Upon information and belief, Copeland stated that he would sit in jail for 2 years rather than testify. Upon information and belief, Chief Judge Glanville informed Copeland that Chief Judge Glanville could keep sworn witness Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial. Upon information and belief, ADA Love, or Hilton, informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following the above coercive actions by Chief Judge Glanville in conjunction with one or more attorneys from the Fulton County DA's office, sworn witness Copeland stated at the ex parte meeting that he would testify. Upon information and belief, the Chief Judge Glanville also presented sworn witness Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Upon information and belief, sworn witness Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. Upon information and belief, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute sworn witness Copeland if he were to lie on the stand. Upon information and belief, sworn witness Copeland also stated to ADA Hilton that he would testify that he killed Devon Thomas Jr. Upon information and belief, in response to sworn witness Copeland stating to ADA Hilton that he would testify that he killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified he killed Thomas. Oh my goodness. During court on the afternoon of June 10th, when one or more of the above allegations were presented to the court by Attorney Steele, Chief Judge Glanville denied that one or more events above related to him were accurate. The judge must cease to act and must make an immediate determination. When a trial judge is presented with a recusal motion and an accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely, whether the affidavit is legally sufficient, and whether the affidavit sets forth facts that, if proved, it says proved, but proved, would warrant the assigned judge's recusal from this case. The present motion for recusal is being timely submitted to the court. The present motion is being filed and presented to the court in a timely manner. Uniform Superior Court Rule 25 governs motions for recusal. Motions to recuse, along with accompanying affidavits, are required to be submitted to the presiding judge not later than 5 days after the affiant learns of the alleged grounds for disqualification. Such submissions shall be submitted no later than 10 days prior to the hearing or trial, which is subject of recusal, unless good cause is shown for failure to meet the time requirements. Given that the most recent incident demanding recusal just occurred on June 10th, a 2-day period elapsing from the incident requiring recusal to the filing of the present motion is good cause. The present motion includes a sufficient affidavit demonstrating the need for recusal. An accompanying affidavit by Douglas Weinstein, Exhibit 1, called the Weinstein Affidavit, with evidence for recusal has been filed and is now presented, which fully asserts facts upon which this motion is founded as required by law or code. A review of the Weinstein Affidavit shows that it clearly states facts and reasons for the belief that bias or prejudice exists, as is required by USCR 25.2. The Weinstein Affidavit is specific with respect to time, place, and persons and circumstances in which demonstrate bias in favor of the state that prevents impartiality in the present case, as required by code. The particulars of the Weinstein Affidavit are provided above and need not be presented again here in detail, but lays out alleged actions of Chief Judge Glanville in conjunction with the state with respect to sworn witness Copeland that took place in the chambers of Chief Judge on June 10th. Recusal is warranted based on the facts alleged in the Weinstein Affidavit. The facts alleged in the Weinstein Affidavit must be assumed to be true when deciding whether recusal would be warranted. The details learned by Weinstein upon information and belief detail the holding of an improper ex parte hearing conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick, including the right to due process and a fair trial. The ex parte hearing with sworn witness Copeland was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct. And here's the copy of it. Let's see. Uniform Superior Court Rule 4.1 generally prohibits ex parte communications except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of an extraordinary matters, such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. Also, Georgia Code of Judicial Conduct 2.9 says assuring fair hearings and averting ex parte communications provides that judges should accord to every person who has a legal interest in a proceeding or that person's lawyer the right to be heard according to the law. Judges shall not initiate, permit, or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. 1. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided that A, the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication, and B, the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. Second exception, judges may obtain the advice of a disinterested expert on the law and applicable to the proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice and afford the parties a reasonable opportunity to respond. Third exception, judges may consult with the court and staff and court officials whose functions are to aid in carrying out adjudicative responsibilities, or with other judges, provided the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate their responsibility personally to decide the matter. So he can't say, hey, what would you do? Yeah, and then do that. Judges may, with the consent of both parties, this is the fourth exception, confer separately with the parties or their lawyers in an effort to mediate or settle pending proceedings. So, continuing the sentence here. The ex parte hearing with sworn witness Copeland was in violation of at least Section 2.9 of the Georgia Code of Judicial Conduct, which assures every person, including persons such as Mr. Kendrick, a fair hearing. Ex parte communications are presumed to have been in error. Rule 2.11a in the revised Georgia Code of Judicial Conduct says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations which recusal is required. The standard is an objective one. The facts must be considered from the perspective of a reasonable person rather than the perception of interested parties or their lawyer advocates, or from the subjective perspective of the judge whose continued presence in the case is at issue. Furthermore, Chief Judge Glanville should not have coerced sworn witness Copeland to testify. A trial judge should not attempt to intimidate a witness to testify in behalf of the state, either in or out of the presence of the jury. As the Georgia Supreme Court wrote, we need not decide whether such bias and impartiality actually existed because judges are ethically bound to disqualify themselves whenever their impartiality might reasonably be questioned, including instances where the judge's behavior could indicate that he or she has a personal bias or prejudice concerning a party or a party's lawyer. Defendants were not provided notice of the hearing either before, during, or after, and regardless, defendants should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. The only logical conclusion to be drawn by the willful exclusion of all defense counsel from the meeting among Chief Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the sworn witness into testifying. Given that the facts as alleged must be assumed to be true, the Weinstein affidavit is sufficient, and that recusal should be authorized under the alleged facts. Another judge should be assigned to hear this motion to recuse. Wherefore, Mr. Kendrick respectfully submits that the present motion meets all requirements of USCR 25.1, .2, and .3, and this motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested motion relief in this motion to recuse, Mr. Kendrick requests that the court make a specific factual findings and submits that Chief Judge Glanville should voluntarily recuse himself. Should the court take neither of the above actions, Mr. Kendrick moves this court for a mistrial due to the ongoing bias of the court as evidenced in the Weinstein affidavit and on the basis that Mr. Kendrick is not receiving a fair trial as his constitutional right of due process and under the Sixth Amendment. Should all of the above requested relief be denied, Mr. Kendrick requests a certificate of immediate review. The footnotes here say a critical stage is one in which the defendant's rights may be lost, defense is waived, privileges claimed or waived, or one of which the outcome of the case is substantially affected in some other way. This is the star witness from the state. During the course of a trial, there appears to be an internal inconsistency between Rule 25.1, which mandates that a motion for recusal shall not delay the trial, and Rule 25.3, which mandates that the judge temporarily cease to act upon the merits of the matter. Mr. Kendrick submits that the court can reconcile the intent of these rules by briefly hearing the motion to determine the timeliness and sufficiency of the Weinstein affidavit and make necessary determination without delaying the trial. The court regularly hears motions during the course of the present trial, and this motion is no different. And it's dated this 12th day of June, 2024. Now, we scroll down and it's got the law firms attached. We scroll down because here, Rule Nisi. Wherefore, the defendant having filed a motion to recuse the above captioned matter, it is hereby ordered that the defendant's above motion shall be set down for hearing on a certain date, to wit, on the blank day of blank at blank o'clock a.m. in the courtroom of blank in the Superior Court of... He gave him a fill in the blank. He gave him a fill in the blank, even wrote the judge's name on the bottom. This is where you sign. This is where you sign, Judge. So here's your order. Certificate of service. This is to certify that I have this day served a copy of the foregoing document. Where's the Weinstein document? We need that. Here it is. Weinstein affidavit in support of a motion to recuse Chief Judge Ural Glanville. Personally appeared before the undersigned officer duly authorized to administer oaths, Douglas S. Weinstein, who, upon being duly sworn, deposes and states the following under oath and penalty of perjury. Number 1, sworn witness, Kenneth Copeland, had been held in civil contempt of court on June 7th for refusing to testify on that date, and after being given a grant of immunity by Chief Judge Glanville, who is presiding over the present case, Chief Judge Glanville instructed the witness and all parties on June 7th that Copeland would be jailed and returned to court on June 10th at 8:30 a.m., where he would announce whether he was prepared to testify. Upon information and belief, defense counsel were all present in the courthouse at 8:30 a.m. on June 10th. Defense counsel were present in the courtroom 1C by 9 a.m. on June 10th. It looks like it's in there twice. One guy was late. Upon information and belief, an ex parte meeting was held in Chief Judge Ural Glanville's chambers on June 10th. Among Chief Judge Ural Glanville, ADA Love, ADA Hilton, other members of the Fulton County District Attorney's Office, deputies, sworn witness Kenneth Copeland, and Copeland's attorney. No member of defense counsel for any of the defendants in the present case was present at the ex parte meeting. Upon information and belief, no member of defense counsel was aware of the ex parte meeting before or while the meeting was taking place. Sometime between 11 a.m. and 11:30 on June 10th, Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. At that time, Attorney Steele, counsel for Mr. Williams, inquired with the court as to what had occurred prior to Chief Judge Glanville taking the bench, and his inquiry was not accepted. Copeland briefly testified prior to lunch recess on June 10th. Upon information and belief, at the ex parte meeting on the morning of June 10th, Copeland announced that he would invoke his Fifth Amendment rights and not testify. So Copeland says, I'm not going to testify. I'm not going to say something that would incriminate myself. Upon information and belief, at the ex parte meeting on the morning of June 10th, Copeland stated that he would sit in jail for 2 years rather than testify. Upon information and belief, at the ex parte meeting on the morning of June 10th, Chief Judge Glanville informed Copeland that C.J. Glanville could keep Copeland incarcerated until additional defendants were tried, not just the 6 defendants currently on trial, 6 of the 27. So he threatened him with basically perpetual incarceration. Upon information and belief, at the ex parte meeting the morning of June 10th, 2024, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. Upon information and belief, following in the above coercive actions by Chief Judge Glanville in conjunction with one or more attorneys from Fulton County District Attorney Office, Copeland stated at the ex parte meeting that he would testify. He caved. He said, okay, I will. I don't want to spend the rest of my life in jail. Upon information and belief, Chief Judge Glanville also presented Copeland with a printout of the perjury statute and the false statement statute of the state of Georgia during the ex parte meeting. Upon information and belief, on the morning of June 10th, in Chief Judge Glanville's chambers, Copeland stated to ADA Hilton that if called to testify, he would simply lie on the stand. He's like, okay, I'll testify, but I'm going to lie. Upon information and belief, on the morning of June 10th, the Chief Judge Glanville's chambers, in response to Copeland's statement that he would lie, ADA Hilton stated that she would not prosecute Copeland if he were to lie on the stand. So what does Copeland do? He says, okay, part 19, that he's going to state that he killed Donovan Thomas Jr. in his testimony on the stand. The Chief Judge, the ADA Hilton, in response to that, said that, stating to ADA Hilton that he would state that he had killed Donovan Thomas Jr., ADA Hilton told Copeland that she would prosecute him for perjury if he testified that he killed Thomas. Because she said, I won't testify. I won't charge you for anything you say. He says, I'm going to lie if I get up there. She's like, if you lie, I'm not going to prosecute you. Okay, I'm going to say that I killed the guy. She's like, well, if you do that, I'm going to charge you for perjury. During the court, on the afternoon of June 10th, when one or more of the above allegations were presented to the court, Chief Judge Glanville denied that one or more of the events above relayed to him were accurate. Further, affiant saith not. And this dated the 12th day of June, 2024, and it's stamped. Okay, so put this all in context, okay? Put this all in context. The judge, yesterday, we watched just a little bit right around lunchtime. The judge, the witness Copeland, was on the stand. He was testifying, and his lawyer was there in the light green shirt, remember? And the lawyer's like, oh, by the way, I quit. And Mr. Copeland said, yeah, she's fired. I don't want her. I want a different attorney. I don't want her. And the judge made a big stink of this and did not want to let her go. And the defense counsel chimed in and said, hey, here in the rules, it shows that if both sides agree to being separated, like the lawyer and the client, you waive the whole 10-day period, and she can just immediately be released. Judge was big mad. Big mad. And instead said, okay, I'm gonna release you after a significant break. I'm gonna release you, but I order you to come back for a show cause hearing on the 25th. I'm releasing you, but I order you to show cause. The show cause is basically you have to explain why this happened. And you think, why would he want to do that? Because his interest, the judge's interest, is in finding who the mole was, who talked about that ex parte meeting that no one else was supposed to know about. And he's mad about that. And so he thinks that maybe this lawyer did. That this lawyer told the other lawyers. Is that the reason why she said, hey, I quit. I don't want to be any part of this? If it was, then maybe that would explain why somebody with her name, possibly that lawyer, was in Law and Crime's chat yesterday explaining why they left and how this is a circus act and she doesn't want to be any part of it. If that was her, that sure stands to reason that makes sense. You cannot make this stuff up. Oh my goodness. Yeah, we have screenshots of the Law and Crime text chat of somebody by that lawyer's name making those comments. The judge appears to have violated the rules in a big way. Let's see, you're saying I've got some... There might be a video of this. Let me just double check. Time-stamped 5:45. Just 1 second here. Let's see if we can send this to... Let's send this here. Just 1 second. Bing! You've got mail. Nope. Don't want that. Skip that. Pause. Just switch accounts so that it won't do that. Let's see if we can bring in just this clip. Have to get this off the screen first. There we go. See if we can just bring in this clip here, and you said the timestamp is at 5:45. Okay, let's do this, shall we? Audio on 7. Let's take that live. See if we got something here.
My attention, Mr. Weinstein, you have filed a motion to recuse me. You have filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.22. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I'd invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation.
No.
You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value. Okay. All right. I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling, and as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you're always talking about how the appellate court...
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
and I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you grant...
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. I just, as a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that, tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that. I'm not.
Would you make factual findings regarding?
I am not at this point in time going to. I've denied the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
Okay. So that happened. That's how it went down. That's the lawyer who filed this. As far as the lawyer who was sentenced to jail for contempt, he filed an emergency appeal, right? And he says he sent it to the I think he sent it to the Appellate Court or something, or the Supreme Court, and they said, hey, it has to go to the other one. But he filed with both courts. he blanketed to everyone who will listen. Here's my appeal. This information just came in that judgment supersedis granted. All the justices concur except Peterson. PJ not participating, meaning that that he will not be serving jail time while his motion to appeal the ruling that he serves jail time for this is reviewed. So unfortunately, no weekend jail visits for Mr. Williams by Mr. Steele. They don't get to have they don't get to be bunk buddies or have sleepovers at the jail until this gets sorted out. This is turning into a train wreck. I think the judge is trying frantically to plug all the holes in the dam, and he's quickly running out of fingers. This is crazy. He should recuse himself. The problem is this case has a problem. This case has a problem because it is so unwieldy. It is so ginormous and misformed and just because of how many people there are. Because of how many defendants and how many motions and how many, the whole process, our judicial process was not designed to handle cases like this. They take forever. It's grinded to a halt, and the opportunity for something to go wrong at some point with all the different moving parts and pieces is massive. And I think at this point it has gone wrong. Oh man. So with that, I guess the Young Thug trial for the time being will continue. Mr. Steele will not be visiting the jail this weekend. And we'll see what happens tomorrow, because every day is a new day. And we're only halfway through the work week. There you go. All right, that keeps you up to date, and now we've kept you up to date on all the things we've been following. The only one we're still waiting for this week is a letter from Sarah Boone. I've rumored to be 58 pages, which is a lot to read, but I'll do it. Let's see, I'm doing a rechecking right now to see if anything else has been filed in her case. And it has not. Nothing yet. The latest from Sarah Boone's case is her lawyer wants to quit as well. So there's a hearing that's going to be coming up for that one. Well, the judge determines if that lawyer, Attorney Cashman, is allowed to be the 8th lawyer to bail on Sarah Boone. All right. And there we have it. We do have a podcast tomorrow if you want a little break from all this crazy court action, or just you want to hang out with some cool people. Join us here tonight, not tonight, tomorrow night at 8 p.m. on this channel. Hey, bring a friend. Have fun. It's a live podcast. Your input is not only encouraged, but welcomed and appreciated. So please come join us live for the podcast. It'll be a lot of fun. Weatherwatch and I do this podcast. We've been doing it for a long time now. We're coming up on, 18 months. It's been a while, but it's wonderful. Thank you very much for everybody tonight. When you go home, please hug the people you love. Smile at someone. Make your day just a little bit better, and please stay safe till we go live again, which will be tomorrow about 8:30ish. 8:30, 8:45ish. Don't hold me to the 8:30. All right, 8:30 is really hard time to be done. Other than that, you guys have a good night. There's plenty of other great content here on LawTube because we have great creators all across the board. You guys be good to each other. We'll see you tomorrow. Bye-bye.
Alex stole it as well.
There's a lawsuit.